Well, of course, the writing of the Constitution in 1787 was followed by a very powerful debate over ratification. States had to ratify, 9 states had to ratify the Constitution for it to go into effect. Now, many critics of the Constitution, the so-called anti-federalists, the Federalists were the people supporting this Constitution, the anti-federalists claimed that the Constitution was creating a government which would be too powerful, a central national government which would ride roughshod over the rights of the states and of individuals. Many of the state constitutions had bills of rights, indicating the basic civil liberties of citizens. The original Constitution, the original federal Constitution, didn't have one. James Madison, the basic author of the Constitution, said we don't need a Bill of Rights because this government is elected by the people. How can the people suppress their own rights? But the Anti-Federalists insisted on this, and basically one of the deals or arrangements that Madison agreed to in order to get ratification in the key states, New York, Virginia, which was strongly divided, was that once the Constitution was ratified, Congress would propose amendments to guarantee these basic individual rights. And in 1791, Congress passed the first 10 amendments, which then were ratified by the states. The Bill of Rights, which, the first one is Congress shall make no law restricting the freedom of speech, freedom of religion, freedom of the press. And it goes on listing, your basic rights, trial by jury, the right to a jury of your peers, the right to a lawyer, the right not to have cruel and unusual punishment, the right not to be forced to be a witness against yourself, etc. And at the end, the Bill of Rights says that all the rights not specifically given to the federal government are retained by the states and the people. So the Bill of Rights was meant to ensure that the national government did not override or suppress the basic liberties of American citizens. It only applied to the national government. At that point, it had nothing to do with the states. The states could suppress your freedom of speech, and they did in many cases, without violating the Bill of Rights, which only refers to Congress and the federal government. But the Bill of Rights becomes a sort of key statement of American liberty. But for many years, it was not really enforced. It was not really, or was violated in many instances. Later on, after the Civil War and then into the 20th century, many of these protections are then applied to the state governments as well as the federal government. It's really only in the 20th century that we get a whole jurisprudence of civil liberties. That is, that courts begin handing down decisions protecting the rights inscribed in the Bill of Rights. So it takes a long time for the Bill of Rights really to become a living, vital part of our legal judicial system.